Hello, you are on to Law Minstrel. I am Mwese Modukbe Nye. This episode is the second part of the lecture we are doing on terms of a contract of sale of goods. In the first part, we looked at such terms as condition and warranties. This is the second part. We'll be looking at exemption clauses. Kindly let me pause here and enjoin you to be a member of our community if you are not, by clicking on the subscribe button. This will make you automatically subscribed as a member of our community and will grant you access to any of our videos as they drop. You also have access to our freebies that are exclusively for our community members. I'd like to also enjoin you to give us a thumb up by clicking on the like button if you have enjoyed any part of this video at any point thereof, and you can give us a comment in the comment section on anything you would like or to pass across to us. I'll look at it, make a response where I have to make one, and then also take action where the comment envisages that I should take one action or the other. We also enjoin you to share this video to your loved ones or your colleagues or on any platform you think is relevant it should be on. Thank you very much. So we'll now go to the business of the day on this episode. We'll look at what exemption clauses are. Exemption clauses, also called exclusion and or limitation clauses, are called those things because they seek to limit, they seek to exclude, or they seek to exempt a party's liability for a breach of a term in a contract. I really hope that is clearly understood. These terms we are looking at are exemption clauses. An exemption clause is also an exemption term and is also termed as an exclusion term or a limitation term. I'm simply saying that the meaning of these terms lies in the words that they are given. So it's an exemption term or clause because it exempts someone. It's an exclusionary clause because it does what? It excludes someone. It's a limitation clause because it does what? It limits someone. And what is it limiting? Or what is it excluding? Or what is it exempting a person from? It is doing that. It is exempting him or excluding him or limiting him in terms of the liability he would have suffered for breaching a particular term in a contract, whether that term is a condition or the term is a warranty. So, exemption clauses are extremely common in commercial contracts, especially in standard form contracts, but they are often controversial. They are often controversial because they can unfairly limit a party's rights. Now, understanding them is essential to both drafting contracts and litigating disputes, or even solving problem questions when they come to you in an exam. So what really is an exemption clause? An exemption clause is a contractual term that modifies the ordinary obligation under a contract. So for example, the seller shall not be liable for any defects in the goods sold. You know, this type of term is an exclusionary term. It's an exemption term. It is a limitation clause. It's limiting the person and protecting him from the liability he would have gotten from breaching a term in a contract. And this term could be a condition because the buyer couldn't have ordinarily been contracting to buy defective goods. So this is what could have made the buyer place the buyer in a position to be able to repudiate the contract, as treat it as having been ended. But this clause now excludes the seller from that type of liability. So when you look at it critically, it appears that exclusionary clauses could unfairly limit the liability that a party could have borne ordinarily. So this clause attempts to exclude liability for implied conditions or warranties, like fitness for purpose or correspondence with the description. However, the courts do not allow parties to evade their fundamental obligations lightly. The courts normally try to fight to protect the party, to act as protecting the party who has been unfairly treated in relation to unfair exclusionary clauses. Whether an exemption clause is valid depends on how clearly it is expressed and whether it was incorporated into the contract. So how do you incorporate exemption clauses into contract? For example, for an exemption clause to have legal effect, it must be incorporated into the contract, and there are three main ways that you can do this. You can do this by signature, you can do this by notice, and you can do this by consistent course of dealings. Let's start from doing so by signature. If the parties sign a contract containing an exemption clause, the clause is generally binding even if the party did not read it. And that's why it's important that parties should read or study their contractual documents. If you have a problem with understanding it, you may get a second help or even get a legal practitioner to go over it with you. So in the case of Lestrange versus Grocop, for instance, citation supplied, signing a contract containing exclusion clauses binds the party as long as the party has signed it. We'll now look at how they can be inserted by notice. If the party relying on that clause gives reasonable notice before or at the time of contracting, it may be effective. So, for example, terms printed on a ticket or an invoice may be binding if the recipient had reasonable notice. Finally, we'll look at doing so by consistent course of dealings. A clause may also be incorporated if both parties have consistently included it in previous transaction. Let's now take a look at construction of exemption clauses. Once incorporated, the construction of the clause determines whether it actually excludes the liability in question, because how they were constructed will determine whether they will actually exclude the liability that they seek to exclude the party from. Let's look at the principles that courts follow in looking at whether an exemption clause is enforceable or it cannot be enforced. 1. Clear and unambiguous language employed. The requirement is for clear and unambiguous language. Ambiguous construction in contractual documents are usually construed in favor of the preference. Now, what do we mean by this? Any ambiguity in a contractual document is interpreted on the principle of contra proferentem. That means that the ambiguities are usually interpreted in favor, is always interpreted against the preference. A preference is the person that is preferring or adducing to a contract or a condition within a contract. So, and that's why it's important that there should not be ambiguities. The exemption clause should be crafted in a language that is clear and is unambiguous, because if it's ambiguous, the court would have to rely on the principle of contra preferentem to interpret the ambiguity. The second thing is that the clause must cover the type of liability arising from the breach. Courts will not extend it by implication. So if it doesn't cover it, the liability is talking about completely, the court is not going to extend the language to cover the liability in the manner you want. So it must cover the type of liability properly and completely as you seek to cover. And finally, the matter of fundamental breach. So historically, courts held that a party could not rely on an exemption clause if the breach went to the root of the contract. So the clause in issue should not go to a fundamental breach. Otherwise, courts will be reluctant to enforce them. Let's look at Nigerian approach to a fundamental breach in a sale of goods. In Nigeria, the treatment of fundamental breach in relation to exemption clauses has been clarified in recent decades. We'll look at the case of Ogu versus Leventis Motors Limited earlier given. In that case, the seller delivered a car that was wholly different from what was described, and the court held that the exemption clause could not protect the seller because he committed a fundamental breach. In the case of Naruma and Sons Nigeria Limited versus Niger Benue Transport Company Limited, it's a 1989 case. The Supreme Court emphasized that the effectiveness of an exemption clause depends on the construction of the contract and the intention of the parties thereto the contract. So there is no absolute rule barring reliance on a clause in fundamental breach. What matters is whether the clause is clearly worded to cover the breach. So in Nigeria today, the key question that arises is, did the parties intend the clause to cover the particular breach in issue? We'll look at now exemption clauses and implied terms. Exemption clauses and implied terms. An important point is the interaction with statutory implied terms. Let's take a look at the interaction with statutory implied terms. And the first we'll be looking at is implied conditions and warranties cannot easily be excluded, especially if the clause is vague. And 2, courts will interpret the clause narrowly to avoid undermining statutory protections unless the language clearly and expressly excludes the liability. A good example is that which we gave in Ogu versus Leventis Motor Supra. So an exemption clause cannot be used as a shield for dishonesty of fundamental non-performance. That's it. We'll now look at the common law principles and commonwealth parallels as relates to exemption clauses. And our first stop will be at English law. The English approach mirrors Nigeria's approach, or vice versa, but with statutory refinement. So the Sale of Goods Act of the UK 1979 allows exclusion clauses but construes them strictly. Also, the Unfair Contract Terms Act of 1977 of the UK now regulates unfair terms, especially for consumers. This limits the effectiveness of exemption clauses in cases of negligence or in cases of breach of an implied term. And in other commonwealth jurisdictions like Australia, the Australian consumer law prevents sellers from excluding statutory guarantees of fitness and mercantile quality in consumer contracts. In Canada, for instance, similar protections exist under provincial consumer statutes. Now, in Nigeria, while statutory consumer protections are less developed, the FCCPA of 2018 strengthens oversight, making it clear that exemption clauses cannot undermine statutory guarantees of fairness. So now, let's look at drafting considerations for exemption clauses. What are the considerations you should consider if you are going to draft an exemption clause? When drafting an exemption clause or advising a client in relation to an exemption clause, keep the following points in mind. The first is the use of clear and specific language. Avoid vague wordings. The second is notice and incorporation. By this, you will ensure that the other party has accepted the clause. Then thirdly, you will look at scope and limitation. By this, you will define which liabilities are excluded and whether any limitation on damages is reasonable. Then 4, and the final one, you look at public policy and fairness generally. Nigerian courts may refuse to enforce clauses that are unconscionable or are fraudulent. Let's now examine policy and practical considerations. Exemption clauses balance freedom of contract and protection against unfair terms. In commercial contracts, parties value certainty and risk allocation. Parties would always value certainty and risk allocation. Who bears the risk, where the risk falls to. So, courts intervene when clauses attempt to excuse fundamental non-performance, fraud, or great negligence. As legal practitioners or even as a law student, we must advise clients carefully. You advise clients carefully. Even as a law student, in your problem questions, you will be asked to advise a client. Sometimes you'll be addressed as a counsel. A client has come to you in chambers with so and so, counsel him, advise him. So even as law students, you will be advising those fictitious clients. As legal practitioners or even as law students, in advising clients, we must do so carefully. And in doing so, we are doing so either to ensure enforceable limitation clauses or to avoid clauses that will likely be struck down by the courts when those issues come before the court. So, by way of conclusion, generally, exemption clauses are valid, but they are valid only if properly incorporated and carefully drafted in the contract. 2. Nigerian courts construe them strictly and scrutinize their applicability in cases of fundamental breach, so you have to be careful. Again, while freedom of contract is respected, public policy, statutory implied terms, and fairness are always paramount, and there are other statutes that protect this. Then, finally, comparative Commonwealth insights show increasing regulation of exemption clauses in consumer and commercial law. Understanding exemption clauses is critical. It's critical for drafting contracts and litigating sales disputes generally. So the misuse of these clauses can lead to unenforceable provisions and legal liability. You'd have thought you have done a great job for your client, but when a dispute arises and they go to court, you see everything falling down like a pack of cards. So you have to be careful. And with this, we have come to the end of this episode on terms in a contract of sale of goods. Thank you so much for staying with us through this episode. If you have enjoyed the episode, kindly give us a feedback by way of clicking on the like button, as well as giving us a comment in the comment section. And you can share this with your loved ones or persons within your sphere of influence. And you have not subscribed to our channel, please kindly do so. Till next time, I am Kwesi.